Schmidt matter, you testified, I believe, as to, and you referenced it here about invoices being plussed up. Do you recall that testimony? Can you describe what is meant by an invoice being plussed up?
Well, plussed up, depending on whether it's a flat fee, whether it is, percentage based. Obviously, oftentimes vendors will plus up an invoice, put a little profit on there to run the operation.
So specifically in Schmidt's case, the argument was that the invoices have been plussed up to cover, for example, your costs. Do you remember that testimony?
Vaguely,
Okay. Do you believe that invoices were plussed up to cover your costs?
I do.
Okay.
Objection, relevance.
Do you believe that this invoice was plussed up? Do you believe that the invoice at K was plussed up for your time?
I have no idea. I spent a lot of time, working with Rep Schmidt on her invoices. I have not, Mr. Stewart, so I can't answer that.
So do you believe that there was an inconsistent approach within Constant Content for sometimes they were plussed up and sometimes they weren't, or you have no knowledge?
I have no knowledge of that.
I'm just trying to clarify, and it's very relevant because in the prior case, the argument was that the invoices have been plussed up to cover time for him, for Fitzmartin, et cetera.
That's
So
nothing to do with the allegations against Representative Stewart.
It
Well, they
would,
were-
yes, it would, because it would imply that buried within this invoice were activities that were paying for consulting services being provided by humans, which is exactly what was argued in the Gene Schmidt case. Is that the human consulting was not exogenously separately invoiced, but that it was put in a plus up on Constant Content invoices. That's why it's relevant.
We are so far beyond the scope of his complaint. I've lost track.
I'm not surprised, but the point is, you want questions not to be asked. I want to make sure that we have clarity here, Mr. Stewart.
Let's ask and answer with the.
They're the one, then
Let's go ahead and just keep it moving, guys. Conjecture is not helping the case.
I believe that, okay. So, where do you know where I obtained the Brian Stewart radio ad?
I don't.
Okay. For reference, I obtained it from Brian Stewart. As part of discovery in the process. Okay, that's, I believe. Those are my questions. Thank you.
All right, thank you. Any other?
I have none.
Okay, is he excused?
No.
How could he not be excused?
He could be recalled. They still haven't presented their case.
Oh, well. Are you gonna? Okay.
Something could come up in their case that would make me want to recall him.
All right, Stephen, back to the hole.
I,
You have to
Commissioners,
go at 4:45.
Commissioners, I have an absolute hard stop. I'm expected to give a presentation in one of our counties. That is my livelihood. So I will leave this building at 4:45, and I say that with every ounce of respect that I have for this commission. Thank you.
Thank you for your time.
All right, thank you.
And I'd like to call Nick Owens.
Objection.
He's not present, and I think I indicated he needed to be present in order to testify.
I've spoke with Mr. Hughes several times that starting in 2025, respondents and witnesses were going to be able to be virtual. I have been in things where you have sworn people in virtually.
We will do that during preliminary reviews, but not during a hearing.
So that's and I also want to point out to you, Mr. Richter, that I emailed you over a week ago telling you of a plan to have Nick Owens on standby to testify virtually. You never responded till yesterday afternoon.
Okay, he needs to be present in order to testify.
Okay, then I want to move for a continuance so that he can be present physically.
Objection. He's
object.
never
The
been.
point is, why are you making it so hard for somebody who's available, can be sworn and wants to testify via Teams to do so? How's that in the interest of the people of Ohio who are adjudicating this case?
No, I mean, presumably what you're gonna call Mr. Owens for is to rebut what Mr. Caraway said. In your question, I think you've already gotten that across. I don't think there's any need to have Mr. Owens further testify. I believe it's appropriate to have him physically present to
Then I want
testify.
to
in
offer the
case.
questions I would have asked him and the answers that I believe. he would
Offer
give.
that to the commission then at the
Okay.
appropriate time.
Now the appropriate time?
If there are no other witnesses, would it be?
So I'm gonna want to proffer testimony for that based on you not allowing somebody who's available to be a witness, who I was told starting in 25 could be done virtually.
I know, I would like to state for precedent's sake, it has not been permitted beyond the scope of when we were fully virtual. That was mandated by the state of Ohio. We have had the precedent outside of that context where everything was virtual, that if it is a full hearing, the expectation is that you would be in person to testify. That is the precedent. So breaking from that would actually create the rodeo that you all say that we take you on a weekly basis. So for one time, we would just like to remain consistent. Thank you.
So I just want to, I want to proffer that in, but that I contacted Mr. Richter over a week ago about this and never got a response till last night. So I never had an opportunity to try to get Mr. Owens to change his plans. And as I've said, I previously have asked Chris about that starting in 2025, that witnesses and respondents and complainants will be able to appear virtually.
You made your point, move on.
Madam Chair, if I would, the decision was made. This is certainly not a debate that we're not going to allow for video testimony. That issue is behind us. I think the issue prior to proffering, which I would not agree with, but if we proceed with the proffer, the question was whether there are any other witnesses before that occurs. I did not hear an answer to that question.
Let me restate the answer that I gave, is that I want to proffer the testimony. I got interrupted in the middle of it, but would have been then Nick Owens. But also I want to proffer testimony for both Don Bray and Natalie Bauer. Both of which I've been declined. I want to preserve that for appellate purposes. Because they're two witnesses that were directly involved and been repeatedly referenced that I was prohibited from being able to call.
You can submit that in writing.
Now, I can also do per the OAC, I can do a verbal proffer to make sure it's in the transcript.
Proceed.
Well, I haven't heard though, are there any other witnesses?
No, not beyond what I want to proffer.
And then just really quick, I've got,
2 PM, we've
yeah,
got you.
that's all. That's.
14
I'm gonna
minutes.
read it off, so since nobody's gonna, unless you're gonna object when I'm proffering.
14 minutes, we will break on the dot, 2 PM.
What I'm gonna do then, if it's okay, I'll do Don Bray first, Natalie Bauer, and then Nick Owens third.
Go
Okay,
ahead.
so question one I would have asked to Don Bray is, when,
Objection, wait a minute. He can proffer that he would call them as a witness. He's just preserving who he would have called. He's not allowed to read every single question.
Yes, you are.
Ask the witness. That's absurd.
that's a that's
Not
a,
proffer.
yes, it is.
Not every single question. I would have called X witness to talk about this subject matter. That's a proffer.
A proffer is that you put into the record the questions you would have asked and the testimony you believe you would have been in reply to those questions. If it was a jury case, the jury would leave the room while that was going on.
Yeah, so it would be a summary of testimony. It wouldn't be a question by question reading.
I would be done reading the Don Bray page by now.
You've got 3 pages there you're talking about.
I,
All right, gentlemen, let's just get to 2 PM.
Well, Madam Chair, I think that we have a request for a proffer and objection from counsel. So I'd like Mr. Richter to rule with finality on the objections that we can proceed or not.
Get it in the record and you're done.
okay. So question one for Don Bray would have been, when did you consult with Mr. Stewart and Ms. Bauer on these cases? I believe the answer would have been before Mr. Stewart's response affidavit of 4/27.
Yeah, you can't speculate.
Part of a proffer is what you believe the answers would have been.
I'm not gonna go that far with that, no. You're
That's
welcome to
bad.
put what you're.
Well, then that's all great for appellate purposes. But then so you're saying you want me to read the questions I would have asked, but not be allowed to indicate the testimony that I thought would have been received?
I don't believe that that's appropriate, because I mean.
That's a legitimate proffer.
I don't believe so. Proceed.
It's not.
So am I not allowed to read the answers?
Those aren't answers.
It's what I believe they would have testified to.
You're making up.
Well,
this to
but
me.
I guess, and here, this, and maybe,
Yeah, I mean, that's
maybe this
making
will,
up
maybe this will
testimony.
illustrate the point. if you were allowed to put in what you believe the answer would be, then we could all put, then Mr. Stewart and I
You
could.
can.
put it-
You
that-
can, so,
right, that's not a.
and if it was a
that's
jury
that's
trial, the jury would be
that's not a
leaving the room
proffer.
at this
That's
time.
not a proffer. So you can't do that. The proffer is what you,
so I don't know what I'm allowed to do. The chair said to do my proffer. Then when I had an answer, I was told I couldn't do that.
Do your questions that you would have asked, you're welcome to put that in, but your statement.
Okay, question one.
Would occur is inappropriate.
So you're denying me the ability to have what I believe the testimony would have been read into the record.
Yes, because
Okay.
that's not the
Okay.
testimony, that's not the actual.
Okay,
testimony.
question one. When did you consult with Mr. Stewart and Ms. Bauer on these cases? Question two, did you ever consult with Emily Cardelloni, the campaign treasurer? Question three, where were you counsel for Friends of Brian Stewart personally, or for NK Bauer and Associates? Question four, did you have conversations regarding these matters raised in my affidavit that involved Natalie Bauer, who is not Mr. Stewart's treasurer nor a client of yours? Question five, in April of 2022, did the HRCC still exist? Question six, did you consult with Mr. Stewart at the specific direction of the HRCC? Question seven, were you compensated by anyone for the consultation relating to Friends of Brian Stewart? Question eight, did you make Mr. Stewart aware of the 12/16/21 Freeman 2020 G19 decision and its requirement that candidates investigate in good faith? Question 9, did you specifically instruct Mr. Stewart and Mr. Bauer to not investigate or report anything relative to these matters raised in my affidavits? Those are the questions I would have asked Don Bray. Should I continue with the questions I would have asked Natalie Bauer? Question 1, when did you consult with Mr. Stewart and Mr. Bray on these cases? Question 2, did you ever include Emily Cardelloni, the actual campaign treasurer, in any meetings or discussions? Question 3, was Don Bray the counsel for NK Bauer and Associates? Question 4, did you instruct Mr. Stewart not to investigate, for example, by calling strategic media placement, or to report these matters raised by my affidavits? Question 5, did Don Bray specifically instruct you not to investigate by, for example, calling strategic media placement, or report these matters made by my affidavits? Question 6, did Mr. Bray make you aware of the 12/16/21 Freeman 2020 G19 decision and its requirements that candidates investigate in good faith? Question 7, did Brian Stewart specifically instruct you to tell Ms. Cardelloni not to investigate or report the matters raised by my affidavits? And question 8, did you specifically instruct Mr. Bauer, Ms. Bauer, not to investigate, or I'm sorry, that should have said Ms. Cardelloni. Ms. Cardelloni, let me reread it. Question 8, did you specifically instruct Ms. Cardelloni not to investigate, for example, by calling strategic media placement, or report relative to matters raised by my affidavits? Those would have been the questions that I would have asked Natalie Bauer. As it relates to Nick Owens, I don't have them pre-written out. I would have asked Nick Owens of his direct recollection of a conversation with Stephen Caraway relating to making a contribution to the Fairfield County GOP in return for not having to pay the outstanding invoice from Constant Content. That's all.
Thank you. Are you resting your case then?
Yes.
Okay, thank you.
The respondent.
I think I have 8 minutes. So, well,
If you'd rather break, if you think it's disruptive, that's fine.
yeah, it might be. I want to, I mean, just so the commission knows, I'm gonna make a motion for a directed verdict under the Ohio Administrative Code rules and Ohio Civil Rules Civil Procedure, which, you know, I think would only be about 10 minutes or so, but it might be better.
Just to
To
keep it
just-
cohesive. Yeah. Okay. If it's not disruptive, we agree?
Yeah, if I may, Madam Chair, briefly. With that motion, are you going to provide a discussion or rationale, or simply provide the motion?
Well, I was gonna hit some highlights. I mean, I was gonna, there would be some discussion and rationale,
Fair enough.
but not, you know, nothing, just
I think it's important, so.
Yeah, hit some highlights.
Okay, very good. We will return at approximately 2:30. I know you said 15 to 20
Yeah,
minutes, but,
it's just a brief sketch, like it's,
Okay.
yeah, it,
well, I'm good with saying 2:20 if you guys think you can stick to it. I'd like to keep things moving, but
yeah, I can't swear to,
Yeah.
that should be fine.
okay. Well, I would just say everybody else assume to be back by 2:20, and if you're not here, we'll be waiting for you.
Yeah, well, thank you for the break.
Yep, absolutely. Thank you for
Yep, see it.
Thank you.
Well, wait a minute. Okay, there we go. Got it.
All right, very good. We're back and ready to hear from the respondents.
Thank you. The respondents, make a motion for, I guess, for lack of a better phrase, be called directed verdict. So pursuant to the Ohio Administrative Code, I can give the section, it's 3517-1-11 subsection E. It says, at the conclusion of the complainant's case, a respondent may move to dismiss some or all the allegations for which the respondent asserts that the complainant did not produce sufficient evidence. The commission will consider such motion and take action consistent with the evidence presented. So in other words, in obviously in layman's terms, as the commission knows, Mr. Hicks has the burden of proof on the allegations in his complaint. And, we've heard a lot of testimony, and I'm certainly not going to go through that, but I am going to highlight a few things because Mr. Hicks has not, frankly, come close to upholding his burden with respect to either allegation. The allegation as it relates to the radio ad and the allegation as it relates to the mail piece. And to highlight a few of the points, I mean, there's been no evidence that Friends of Brian Stewart was made aware that a radio ad was being actually ran. There's been no evidence that Friends of Brian Stewart was informed after the fact that a radio ad was run. There's been no explanation with respect to who authorized placing that ad purchase. We know it was not Friends of Brian Stewart, which is the most important evidence. We know who it wasn't. And we actually do know who it was. It was a gentleman by the name of Brant Fink, which has no affiliation to Friends of Brian Stewart, and no one from Friends of Brian Stewart has ever even had any communication with Mr. Fink. There's been no evidence that Friends of Brian Stewart was actually given notice that an in-kind expenditure had been made in regard to a radio ad, which would have been required, consistent with the evidence. And going with Mr. Hicks's, what appears to be one of his theories is, when Friends of Brian Stewart received a demand from Constant Contact for $13,000, they should have just paid it out of pocket, even though it was a significant amount of time after the election and with the backdrop, and certainly don't need to relive it, but the backdrop of the whole Longstreth connection and Larry Householder and so forth, obviously based upon the evidence that from Representative Stewart and Stephen Caraway, among other people, it was very reasonable both to not pay that and to do due diligence to see whether or not it was even a legitimate debt, which it was not. There was no invoice that's been presented as evidence from Constant Contact to Friends of Brian Stewart. There's no contract between Friends of Brian Stewart and Constant Contact for anything at all. No evidence. No evidence of Friends of Brian Stewart being made aware of any outstanding unpaid debts prior to the filing of the 2020 campaign finance report. None. And none could exist. There's no evidence that any mailer was printed and mailed but not paid for or reported. Everything and you can see from the exhibits, it's every penny in, every penny out is accounted for. What we did get, which really is, I don't even want to go through all the things that, I feel like we've gone, I don't feel like it, I know we've gone down so many different rabbit trails, but when you peel the onion and you evaluate it, there's no evidence in the record with respect to either one of these allegations. And because Mr. Hicks has not carried his burden, the commission, pursuant to Administrative Code 3517-11 subsection E, should dismiss this matter. Thank you.
Mr. Hicks needs an opportunity to reply.
So we did, excuse me, we just heard a lot of there's no evidence and that's there's ample evidence. I just want to be clear, what he read off as a standard for directive verdict, excuse me, is that I have not provided sufficient evidence to make a decision. I believe that I've provided a preponderance of the evidence. I believe that I've met a clear and convincing evidence standard on the actual allegation, not what he said the allegation was, but what the allegation actually is, which is that the campaign finance report or reports were not complete and accurate. Chris, can you put my screen up? Because it'll give me a chance to hit a few of these things of what actually, so if he says I haven't provided sufficient evidence, it would probably be important to know what the actual allegation was, to know what the standard of evidence is. So this is what I allege, 351713 B and C, which is they failed to file a complete and accurate statement. Okay, B and C have to do with differences between timing periods. And then you see they refer to A1 and A2, and that refers to the time periods. Okay, so I don't think there's any question that still to this day, there's a great deal of uncertainty as to whether, I don't think there's any uncertainty actually. I think it's absolutely clear that the post-primary report was not complete and accurate. Boom, fact. That's not a supposition. I think I provided more than enough evidence that that report was not complete and accurate. And notwithstanding, he talks about, well, there was no evidence we got invoice. Well, this was very similar to the other cases that have been tried for the same set of invoices. And that the question becomes also, well, there was a time when he was aware. We know that he was aware that he did a radio ad. He's the one who provided me the radio ad. He did a voiceover. That would have had to happen before March of 2020. That radio ad. We know it exists. Throughout this, he has never done anything to go contact the actual people involved. It's always this sort of rope-a-dope. John Bray says not to do it, but not Scott Schweitzer, not the people that were actually directly involved. He said there's no evidence that it ran. Well, Scott Schweitzer testified to that. The FCC database testifies to that. He said that there's no evidence that he authorized it. Well, if you look, I'm going to point something out. It's page 63 in my exhibits. That I can either run to my computer if you flip it over real quick, Chris, and go to my exhibits. Page 63. Or do you want me to do it? Okay. So yes, there's no evidence. Well, he referenced A. Brandt Fink. If you scroll down here, you'll see A. Brandt Fink at the bottom. If you were involved in the Freeman case that involved a lot of strategy and media placement, who's A. Brandt Fink? He's the person for strategy media who places the ads. He works for Scott Schweitzer. Okay, so all of their things come through this guy who works for strategy and media. And this is the authorization. I don't know about what he was talking about. You know, people have talked about affidavits of this or that. These are the actual, this section, these exhibits are the actual documents. There's ample evidence. Okay, we started with it didn't run to, we didn't, you know, it was, there's no cost to the production to that. We know it grudgingly that it ran, even though somebody didn't hear it on the radio. We know that there were stamp purchases in March and April of 2020 of over $4,000. That makes no sense for no printing purchases. But there's an invoice for printing that never showed up anywhere. So he just stood up here on a motion for a directed verdict and talked about an evidence standard of sufficient evidence. I think I've given you, I think I've easily shown a preponderance of the evidence. You can flip back to my computer. I've easily shown you a preponderance of the evidence. I can show, I think I've met a clear and convincing evidence standard, which is a higher standard than any of these infractions require. Sufficient evidence would mean that I haven't even provided evidence on which any decision could be made. That's absurd. I've clearly done that. So I put up here the actual allegations. So first is the failure to file a complete and accurate statement. By the way, that's a binary. The binary on all the people you have preliminary reviews on. You might cut them a break and not have a fine, but it's a binary. It was either accurate or inaccurate. It's not a judgment call. The other thing I alleged was a violation of 351710D2. So it'd be important to know what the actual allegations are. That the treasurer appointed under Division D1 has to keep a strict account of all contributions whom received and the purpose of which they were dispersed. Now, the treasurers could make the case that they couldn't do that at one point in time because Mr. Stewart was withholding information from them. But then they both testified they became aware of it, at least during me presenting the information to them, that these things existed and that they happened. So the third thing that was in my allegations, by the way, he never went through the statutes that I had done allegations against to point out where I had or hadn't had sufficient evidence. He didn't do what he read out of the Ohio Administrative Code, where he could say, I want to, certain allegations I want taken out of the complaint. Okay, he just said the whole thing. The third area that I alleged was acceptance of corporate contributions. Okay, it's not been paid. Those of you that were here when the Gene Schmidt case happened know that what she ultimately did was record a debt on her campaign finance reports so that then she could, so that she was not intending to pay until legal issues were understood about constant content. But she put something on her campaign finance reports. We've gone through years of this. It's kind of funny. I don't know who was, maybe nobody was here when we did the preliminary review. You were here, Mr. Ricker. Had Mr. Stewart come into that preliminary review and said, yeah, we got an issue, I'm going to record this on my financial reports, you never would have held him over for a hearing. But what happens is people come in here, what makes it the alleged circus is people come in here and they don't just admit, yeah, there's a problem, I'm going to get it straightened out. Yes, I went to Scott Schweitzer personally. Yes, I did this. It's always this rope-a-dope. Don Bray said, don't pay it. Okay, so I think I've had, again, way beyond a sufficient evidence standard. And preponderance of the evidence, I want to put that up here. Preponderance of the evidence, which is the standard for all of the allegations that I presented, including the corporate contributions one, the preponderance of the evidence standard. Preponderance of the evidence means that the complainant must show that their claims are more likely true than not. And my claims were that the campaign finance reports were not complete and accurate. And them being not complete and accurate, the not accounting for that constant content amount would reflect a corporate contribution that's never been reported, but with services that were received. Not hard. So you guys clearly have enough evidence, concrete evidence. I don't know what more evidence you can have than a voiceover that says paid for by friends of Brian Stewart. What more evidence can you have that there was something that was a reportable thing than that? So I think that any motion for directed verdict should be declined. And I also want to say, he once again made the statement, there's no evidence of an invoice. Again, starting with an August of 2021, before my complaint, there was an invoice. It would kind of be like if I had a bill I never paid. Now I could say I received it, or I didn't receive it. But then when I start getting collection notice, I say, well, I never got an invoice. The collection notice has included the invoice. But they still say up here, we never got an invoice. There has never been a good faith, this thing went to me. Oh, there has never been a good faith attempt by Mr. Stewart to do anything to actually fix his financial reports that were clearly not complete and not accurate. That's all I have to say. Thank you.
Brief rebuttal.
So to pick up on the last point, in terms of, obviously there's evidence of an invoice, but the relevant time, and I would encourage you to, please look at those, look at the statutes and so forth, because it underlines the point that there is no evidence. There was no evidence that that invoice was received at the time the 2020 reports were filed. There's no way, and now when we've talked about the invoice enough in terms of that it was not legitimate, but the invoice was not received at the relevant time. So there's nothing that they could have done at that time. And we've heard from Mr. Stewart, we've actually heard essentially in either direct or indirect ways from every witness that everything that Friends of Brian Stewart did at the actual time those reports were filed was correct, and thereafter as information became available. That's the entire essence of everything. There has been no evidence, there's nothing to amend. And like Mr. Stewart said, which is perfect, if he were to amend now, it would almost be it'd be guesswork. There's no evidence of anything that Friends of Brian Stewart did incorrectly. There's been no evidence that an amendment is necessary. We know Mr. Hicks thinks that there's one necessary, but there's no amendment that's necessary. And there's no other easier way to say it, that at the time those 2020 finance reports were filed, they were correct. And any information that came up afterwards didn't change that fact. After due diligence, there's no rope-a-dope. There's just solid, responsible due diligence. And it's also important to note to look at just, this in, a little bit from a mile up. These are candidates for public office, and, the campaign finance reporting is, and it should be, it's very detail oriented. You have to account for everything, every nickel in, every nickel out. In kind, that's the way it should be. Candidates, including Representative Stewart, take that very seriously, which is why they do the due diligence they do, to say, look, do we owe anybody anything? If there was any indication that something was owed, a candidate that has close to $70,000 in their account after the primary in a non-competitive race, I don't care if it's competitive or not competitive race, you're going to pay the invoice and be done with it and move on. So there, again, there's no actual evidence in the record to support these allegations. Just pray the matter gets dismissed. Thank you.
Are there any questions, Commissioner?
Yes, Madam Chair. Actually, for Mr. Richter, I guess I got a couple for you. So, Mr. Richter, have we ever done this in recent history? Granted a directed verdict and second, if we would approve a directed verdict, could you explain that process? And if we denied it, what the process is then?
It's certainly possible. It's certainly possible that the commission has approved a directed verdict. I can't recall a time when it has occurred. And it's not something that we've gotten that often either, presented to us as a part of a case. We used to get them when we were dealing with false statement cases, probably on a fairly regular basis, and the commission would move on. Essentially, so that answers your first question. I can't think of a time. And recently, I can't think of a time when we have even had it presented to us, as I recall. And then it becomes a matter of, essentially, do you accept the arguments that have been propounded by Mr. Garment, or do you accept the arguments and statements that have been provided by Mr. Hicks in assessing the presentation of materials and then all of the other testimony that we have had? And if you believe that Mr. Hicks has provided enough evidence pertaining to, what Mr. Stewart knew and all the rest of the stuff relating to filing campaign finance reports, then I would encourage you to overrule the motion and hold on a second, overrule the motion, and then the commission would move on to hearing whatever else they want to present as a case. Or if you believe that Mr. Garvin is correct and that there hasn't been a sufficient showing of Mr. Stewart's knowledge and whatever else you want to throw out there, then we would approve the request to have a directed verdict and the matter is dismissed. Does that sufficiently answer your question?
partially. So if it's approved, then the case is over, right? Either very simply.
Correct.
If not, then Mr. Garvin would have to either present his case or rest.
He can, you know,
That's
present,
correct.
you know, 15 other, not said you will, 15 other witnesses, et cetera. Or he stands back up and says, okay, we're, you know,
He rests. and
we're resting.
We're-
And,
we're-
you know, and then and then the case is presented before you as it is. And that's kind of where it stands at this point.
Okay, thank you.
Were you gonna? Okay.
Madam Chair, I have a question for the respondent, if that's okay. Mr. Garvin, when you were speaking, you spoke about the ORC 3517.11. I missed the subsection that you stated.
Yes, it is E.
E,
Yes.
I'm gonna interject.
E is in Edward.
I was gonna say, it's administrative code.
oh,
I'm sorry, yeah, I'm sorry. If I said,
It's the commission.
it was probably me, administrative.
yes,
the
and
commission.
if I said the revised code, then I apologize.
That was.
It's the administrative.
Subsection E.
E is, yeah. E
Dash
is
is
in
like
Edward.
35 dash.
Thank you.
You're administrative.
I'm ready for the executive director. Can describe fully the bar for directed verdict.
I mean, it's essentially has the, you know, it's the complainant's obligation to present sufficient evidence that there is a violation. Regardless of what the respondent has put on, he's got an obligation to do that. And so if you believe that what the evidence, all that we have seen over these meetings is not sufficient to establish that there's been a violation of the statute, then you would agree with Mr. Garvin and dismiss the case. I mean, it's a, you know, it's a matter of assessing what has been presented to us by Mr. Hicks.
I guess I asked it in a more manner. I'll individualize it, or just, I guess, hypothetically, if a commissioner were to vote against the directed verdict, and then the defense, like any case, then the defense were to rest. By default, would it be inappropriate for then the commissioner to, would he or she almost be forced to vote in favor of the plaintiff
No.
at that point?
No, I don't believe so.
Okay, so the bar is higher for the verdict than just the. Because the way you described it, to me, the bar would be no different.
Well, I mean, right now, you don't know whether he's going to present additional materials or not.
Yeah,
So I don't know that it's any higher or lower. It's just an assessment of the evidence, but I don't, you know, by voting one way or another here, you're not specifically obligated to vote that way. It may sound strange, but I don't know if there's an obligation for you to vote that way. Just, you know, because certainly, as it relates to a directed verdict, all you're saying is, I don't believe that there's been, you know, in my mind, that I'm ready to decide the case based on the request for a directed verdict.
Okay.
You know, that's what you're assessing, you know, and then because, you know, it's very possible you just want to see it go on. And I would argue that, you know, in thinking back across the years of the commission's times when directed verdicts were requested, again, probably more going back to false statement cases than anything else. There are times the commission said, no, I'm not ready to decide on that. You know, that request, we'll see what, if anything, the respondent has to produce and then make a decision, you know, that's based on the, how do I want to phrase it, the full case, I guess. And then go forward from there, because just because the directed verdict was not approved does not mean that the commission didn't then go on to find, let's say, no violation in the complaint that was alleged.
Okay, thank you.
Madam Chair, if I could. Depending on how this plays out, I could see, you know, to the extent that it's appealed, the conversation from the executive director explaining the standard. So I want to see from counsel's perspective or from the complainant's perspective, either of you have a clarification to provide as to what the executive director explained was the standard. So to make sure that we're all on the same page.
Which one do you want to go first?
We'll let the complainant go first, if that's all right with the chair.
I appreciate actually you asking that question. So, I would equate personally that what they're asking, the sufficient evidence is that making a statement that there wasn't even enough evidence to be able to make any decision. Okay. Violation or no violation. It's equivalent. If I were saying a criminal thing, it would be equivalent to probable cause. There was no probable cause. So we can't even go further than that. He made some, I don't want to go beyond that, but I think that, remember the standards, sufficient evidence, or was there even the basis to make a decision, basically? And then the standard for a decision later is, was there a preponderance of the evidence? Which is, and Mr. Richter can correct me if is it more likely or not that the finance report, for example, was not complete and accurate, or the 11 after it were not complete and accurate because it was never reflected? That's preponderance of the evidence, and that's the standard for most everything through the Election Commission. There's a few that are what's the next one up the ladder?
No, at this point, the commission only went to clear and convincing evidence on false statement cases.
Okay, so so everything here is preponderance of the evidence is more likely to have happened than it didn't. And then sufficient evidence will be for basis for what he's asking for, would be that there was I guess to me, so little evidence provided that there's no basis to even make a no violation decision.
Thank you. No, so it's simple. It's the standard is preponderance of the evidence, and that you would weigh
Not for
the
this.
evidence. It is for this. That is a standard, and I would just suggest putting it up. It was up before, and so you sift all the evidence that Mr. Hicks has developed through whether or not it satisfies the preponderance of the evidence standard. And if you believe that it doesn't, then you would grant our motion. If you believe that it does, then you would deny our motion. So it's simple. It's whether or not, and again, you can put the definition of the standard of preponderance of it on the screen, and you evaluate Mr. Hicks's the testimony and the evidence that he's provided to see if you believe it's satisfied that standard. All right, thank you.
I would like to just object to that characterization. And there's actually different levels: sufficient evidence, preponderance of the evidence, and clear and convincing evidence. For him to say that sufficient evidence also equals preponderance of the evidence is legally false and incorrect.
Madam Chair,
Yes.
I have another question for Mr. Richter, if that's okay. So, Mr. Richter, Phil, let's say we granted a directed verdict. Does that preclude us from having a discussion between the commissioners about the case?
Well,
Do you understand what I'm saying?
I mean,
Typically what we would do is
I'm going to interject you right now. We're kind of doing that right at the moment and having a
Okay.
conversation around here. But I mean, the commission cannot go, into executive session.
No,
You know,
I don't mean that, but we still publicly can ask questions and debate among ourselves where the parties are precluded from interjecting, correct?
Yes, that would be correct.
Okay,
Yes.
so my question, and then under the normal rules, you have 30 days to make, if the commissioners agreed, we could have a discussion today, you still have 30 days to make a decision.
The commission has the ability to hold
Under-
off making a final
under-
determination in a case for up to 30 days. That is
So
correct.
my question is if we granted a directed verdict, does that then not allow us to have discussions?
The case is fully and finally resolved.
Yeah, I'd say
So
that
we
is
can't,
fully
we
finally
can't even, we
resolved.
can't talk about
We
anything?
can talk about the
You-
directed verdict piece now.
No, I don't mean that. I mean,
You can
like,
also discuss.
The case would be fully and finally resolved at that point.
no, you're missing what I'm asking.
No,
You
because
know, have
then,
the full deliberation at this time and the.
I mean, it would be a matter of, we have that motion before us, and if you wanted to hold off on making a decision, we have the ability to do so and not vote on the motion that has been, proposed to the commission, yes. So that could be held off, but if the commission right now votes to, however it votes on the motion that's pending, then it's done and over with in terms of if the commission agrees with the motion. If not, then the case goes forward.
Madam Chair, if I may, I understand the ability to debate a case and issue a final decision after the case has been resolved. I see this as different. I see this as a motion following the complainant resting his case to issue a decision. My feeling is that we should take the motion up by virtue of a vote and certainly not delay the resolution of the matter any longer. Because if it's granted, then the matter is resolved. If it's not granted, then we have a couple of hours to proceed with concluding this hearing today. So I would certainly be against an extended additional time period to reflect upon a motion for directed verdict.
Yeah, that's not what I was asking for, Commissioner. Well, I was just explaining what the procedure is. But my main concern was whether or not we would have any discussion. Apparently, we won't. We'll just take a vote on the verdict. So there's no, I understand, you know, you can talk after all that stuff. I get it. What I'm saying is, we take a vote now and we vote for a directed verdict.
So
It's over. It doesn't allow any of us to ask any questions between ourselves regarding the case.
I'm sorry, but yeah, I mean, if the
That's what I'm
vote's
asking.
taken right now, yes.
if I may, I think I might be able to translate. So
Good luck.
Thank you, Commissioner.
Apparently, my wife might be right.
Commissioner Lyle Vasquez, can we have debate about the facts of the case now
Right.
prior to voting on the directed verdict? Or are we precluded from having said discussion?
You can have that discussion right now. There isn't anything that precludes that.
Okay.
There's nothing
If
that,
that's what everybody wants to do, essentially, you know, I mean, I can't speak for what all, you know, you guys want to do. But you certainly can have the discussion regarding your position. No different than if this was the end of the case and the commission was again discussing, you know, whether it wanted to find a violation or not. That makes sense?
It does now, thanks to Mr. Knight. Thank you.
I'm good at translation, not so good at my own communication.
so I think there are differing opinions or views
Okay.
in that. What Commissioner Kirschner is saying is accurate and true, that we should address the motion at hand, stay in context of the motion at hand, debate within the context of motion at hand, or make a decision to lay that on the table for now, debate the full case. Is that inappropriate? I mean, that was my understanding 2 minutes ago,
I think there's
before we
a
decided
motion that
it
needs to
wasn't.
be voted on.
Exactly.
And if the panel wants to, in an open forum here, debate what they're going to do on the motion, I don't see that as reasonable or unreasonable. But ultimately, I think if there's a motion on the table that needs to be voted upon, we need to make a decision. I'm ready to proceed now with the decision-making process, but if others think they need time to, I guess, have a discussion at this table on the record, that's the choice.
Okay, great. So, in lieu of process discussion, are there any questions of the commission members?
And I'll interject more comments from commission members.
Well, there's no motion.
Yeah, he did make a motion.
Yeah.
The party is moving.
No, the party is moved.
That's
I
right.
understand that.
Right.
Okay, so we don't have to
So
we just vote on it.
Correct.
your decision making, like, if you want to have a conversation.
We don't
right
have to
now.
have.
But you can, if you want, if you have comments you want to make for or against directed verdict,
Yeah.
or questions about direct, you
Yeah, I get
have the
that.
same debate, so, and then when the debate is done, we will vote on the motion.
Okay, I'm good.
Okay, if there are no comments, no questions, no conversations, no deliberations, no debates, is there a motion?
The motion's been made, Madam Chair, I think.
Right,
uh,
is, okay,
And I think that Mr. Richter would just take a roll call vote at that point.
If everybody is,
done. Meeting.
is ready for that, yes.
Commission members ready.
This is vote for or against directed verdict.
Correct. Correct. Give me one more second here as I'm trying to figure out where I'm going. Okay. Mr. Stoutberg,
No.
Ms. Davis,
No.
Mr. Lyle,
No,
Mr. Knight,
No.
Mr. Kirschner,
Yes.
Chair Hagan.
Yay.
Yes, okay. That motion fails 2-4. So now you can put on whatever case you wish to put on.
We rest, thank you. Rest on the evidence.
All right, is
Case
there,
is now, the case is now to the commission.
No, we'd have closing statement.
Okay, yeah, if you want to have closing statements, go ahead.
Did you put my screen up on the? Chris? And then this is. And the opposite of this. More than up here. What else on the screen? Okay, all right. I'm gonna try to be, I think there's 8 charts here or something like that. I'm gonna try to be brief. In a closing statement, because at least we can just learn some about standards of evidence and preponderance of the evidence, so on and so forth. What I started with here, that's a good reference, is a timeline of everything that happened in this case. So you can look at that timeline and see, I think it's very helpful because we can get confused between the September 2021 request for payment and then my complaints and so on and so forth. I'm colorblind, so I can tell what color is yellow on there, but I think the other color is blue or gray or something on there, but my wife is in Florida, so if I don't have nobody to check to tell me what color I made something.
Blue.
So what those are is campaign finance report filings, everything that's in blue. So if you look at I'll go back all the way to the old trail printing. I try to put references to where that was as an exhibit. But just a really quick run through the basics of the timeline. Sometime before 2/21/2020, Mr. Stewart recorded the radio ad. The strategy of media presented an invoice, they had an invoice for it, and 2/21. There were a bunch of stamp purchases around the time that somebody would be sending chasers. The actual primary end rate was 4/28. Sometime after that, Stewart called Longcraft, Caraway, Fitzmartin, and Lippincott looking for outstanding invoices, which there were none before this and none from those calls. 5/18, the contribution to the Fairfield County GOP. Then there's a whole series of reports. There's the original post-primary, I'm sorry, and then pre-general, post-general, semi-annual. My statement was that the campaign finance reports were not complete and accurate. So why I wanted the blue to be visible on there when things were filed is there are lots of opportunities to file something. You know, if you get an invoice, I don't think you'd ever get in trouble if you got an invoice late and you filed it on the new report, the next report you had to file, stuff like that. Well, I just want to point out, there's lots of opportunities to do amendments. There's lots of opportunities to include something on a report. The constant content demand letter was sometime end of 8/21. After that, on 1/31/22, file the annual. So after 1/21, there can be no debate that Mr. Stewart was aware of the invoices. He rejects the demand 9/5. The Freeman's decision was 12/16/21, which I'd encourage you guys to review in any deliberation. Because it speaks to the requirements of a candidate to do real due diligence, going to vendors and so forth to find things out about their which never happened in this case, didn't happen in the Freeman case either. But that's curious because he can't deny he didn't know about it because Don Bray was the person consulting with him. on these matters, and Don Bray was the lawyer in that case. The treasurer change happens from Embry to Cardelloni. Let's remember that throughout all this, the treasurers are never told anything about this, or no documents are shared with them. My first complaint affidavit, Stewart response, which we relied on here. And then you go down this list here, that when I became aware of the Goldstein efforts and so on and so forth, more filings. Contrary to some of the things that have been said, the Freeman appeals were exhausted on 7/23/24, and Mr. Stewart's hearing was less than a month after that. To the point of defending the notion that you guys put the hearings on pause until that case was resolved, and then as soon as it was resolved, they started to move forward, okay? There might have been a little other English involved in this too, but they started to move forward at that point. And then you see when the hearings took place, and an annual was filed during that process. So I just want that timeline. When you guys end up in deliberation, I think the time is over such a long period of time, it's very helpful to be able to see where things happen. I personally feel that it's just a fact that the campaign finance reports were not complete and accurate. That's just a fact. And I believe that Mr. Stewart knew all along. He did the voiceover. He bought the stamps, or his campaign did. I believe he kept asking for invoices because he knew he had received campaign services that were not expensed to him. He did a radio ad. He recorded it. He had a copy of the full radio ad. He knew it was done by a professional outside firm where at least the production cost should have been involved. He did nothing repeatedly to avoid knowing the truth. Could have called up Scott Schweitzer. Didn't. Okay. Filed his response affidavit. And then we come to find he basically hid all of this from his treasurers. Some of them until the actual hearing took place. His stories have not held water. If he had no contract with Constant Content to do any dollar work for him, why would he keep calling Longstreth, Fitzmartin, Caraway, Lippincott, asking him for invoices? Uniquely for Mr. Caraway, only for the post-primary. If the work was HRCC, why did he read a disclaimer saying paid for by friends of Brian Stewart? If the HRCC was in kind directly or by the ORP, why was he asking for invoices? Why wasn't he going to the ORP? Why did he never call Scott Schweitzer or David Goldstein? If the HRCC was in-kinded by the ORP, why didn't he go to Rob Secor from the ORP, who was the executive director handling all in-kinds? If he consulted with Bray, why would he ignore the decision in the Freeman case? Wouldn't it have been obvious if he consulted with Don Bray that you better call the vendors? I just had a case that went on and on with Alan Freeman, and part of that decision was that you have responsibility. And since then, you've had an advisory opinion to that effect. So here, I already put this up before, so I'm not going to dwell on it. What did I actually allege? I didn't allege fraud. I didn't allege this. I didn't allege that. What I alleged was his campaign finance reporting was not complete and accurate. And I believe that has been proven up, down, right, left, and it's still not accurate. I point back to had Mr. Stewart simply early on in this matter stood up and said, hey, we got a little issue here, kind of like what Gene Schmidt ultimately did. I'm going to put a debt on my campaign finance reports. I'm not going to pay it because I question the legality of this whole householder thing, but that'll make at least my reports will have been reported this up. Could have done that. We wouldn't be having these hearings had Brian Stewart walked in more respectful and humbly, I'm going to figure this out and fix it. He knew before my complaints that David Goldstein was requesting the money. He knew that. I also allege that Treasurer didn't keep strict campaign finance reports. 351710D2. I like to be very precise. What did I allege? I also allege that this amounts to the receipt of corporate contributions that have never been reported anywhere. Constant Content was a corporation. I believe that's why Gene Schmidt reported it as a debt, because if you report it as an in-kind, it creates a legal issue because you can't get in-kinds from a corporation. So And you can see this, and you can look at this. I gave you a copy for your deliberations. But, I highlighted some areas here, but I highlighted that knowingly because all of the things that I alleged, the standard is just preponderance of the evidence, more likely to have occurred than not. On this, there's a knowingly element, which is a statutory element as well. You have to know that I'll go and pop back here for a second. There's no knowingly, whether you knew or not, if the campaign finance report was not complete and accurate, it's a violation. On this one, it has to be knowing. I highlighted that in the statute. So it's an element. I actually thought for a long time, Mr. Richter, that this was a clear and convincing evidence standard. Then I realized looking at it just last night, like, no, this was all preponderance of the evidence standard. The standard of the proof for everything I alleged, which is highlighted, is all preponderance of the evidence. Preponderance of the evidence means that the complainant must show that the claims are more likely true than not. So what are the claims? That the campaign finance reports are not complete and accurate. That there was not a strict accounting. Hell, I can tell you there wasn't a strict accounting because he never gave the information to his treasurers. It was hidden from the treasurers. So it says if the evidence tips the scale even slightly in complaint's favor, they met the burden of proof. I put clear and convincing evidence on here because I think I've actually exceeded preponderance of the evidence into a standard that's not even required. Clearly establishes the truth of their claims that the reports were not complete and accurate. I put in here knowingly because it's a statutory thing. And I think the part that I highlighted at the very bottom is the most important part of this. Because what people don't understand, part of being a knowing act is if you willfully try to avoid learning the truth. I heard a gunshot in the other room. Did you think that your wife got shot? Like, I never went through the door. I act in a way not to. Do you think, somebody in the room with her shot her? So it's that last part. You can look at all of it. I highlighted what I thought were the key parts. Fails to make inquiry or acts with conscious purpose to avoid learning the fact. He had every opportunity to go to Scott Schweitzer to actually engage David Goldstein. There's a thing that, David Goldstein didn't respond, but I've never had a problem getting David Goldstein on the phone. Never had a problem getting Scott Schweitzer on the phone. And they're not exactly friends of mine. They're not people that look favorably on me, for dragging them in here and making them testify and so on and so forth, but they've always been very accessible. So the question is, not just this case, but you have to look at the body of cases, Freeman, Schmidt, and what the precedents that you've set. But I think one of the precedents too, that we need to be very careful of, and it just pains me, is that I feel like a lot of political people on these cases that I think are a lot bigger than like a case where, didn't file on time. They just come in and they just don't be accountable. We could have never had any of these hearings if Brian Stewart would have just said early on, yeah, we think there could have been an issue. I'm going to record a debt and we'll take it from there. But instead we've had to go through this litany of pain of, I didn't know about the ad, but you recorded the voiceover. It never ran. Well, it did run. It's just painful. I can tell you if I was in the same situation, I would be immediately saying, yes, I did ad. Yes, it ran. I wouldn't think I needed to hear it personally or come in making a story of, well, I didn't hear it personally, so I didn't know it actually ran. But there's this knowingly standard relating to corporate contribution and I think the question, I think it's hard for your deliberations, is what happens when during the course of a case, it becomes clearer to the respondent that there's an issue and they continue to maintain a story that there isn't. And it can happen in this case. I think it happened in other cases that I've brought, and I think it can happen in future cases, is that somebody comes in and they don't at some point say, hold on, let's take a pause. Maybe I do need to file an amendment. Maybe I need to do this. We've never had them come in and say, in between one hearing and the next, I did go talk to Scott Schweitzer. I did go talk to get an affidavit from the HRCC. So I think on the corporate part, it becomes knowingly. These are the penalties. So the penalties, are for the first part, the 13, the not complete or accurate is $15 to $100 a day. For the treasurer, not keeping an accurate record is $15 to $500 a day. And for the corporate contribution as 105 to 500. So by the way, these are part of the OAC, so the dashes in there tell you it's part of the OAC because your Ohio Administrative Code states what the fine levels are for different violations. So I want to conclude with my last page saying, let's just look at this at the time. Mr. Stewart undeniably had the constant content 3/18/2020 invoice in August of 2021. He undeniably had that invoice because that's when he responded that the invoice wasn't valid. He says he didn't get it 3/18/2020, okay. But we know that he had it August of 2021 because he responded to it. By the way, that was 1,276 days ago. He undeniably had all the strategic media placement invoices in March or April of 2022 based on my complaints. So it's funny how I could get the stuff, no problem. So he had those as part of my complaints, the strategic media placement invoices for his radio placements. He undeniably had the radio station detail by radio station in April of 2023. That was 669 days ago. He undeniably had actual radio station invoices in August of 2024 from the FCC database. The prior one was from Scott Schweitzer, so it was internal documentation of strategic media placement. The second one, the August of 2024, was actual radio station invoices from the radio stations. He wasn't ignorant that there was something going on with the radio. He did a voiceover before 2/21/2020. I'd ask you in your deliberations to comb Exhibit I, his finance reports. Every in-kind from the ORP was specifically for mail and print. Every one. There's not a single ORP in-kind that's for anything other than mail and print. They're all labeled clearly. His pros primary was filed at June of 2020, 1,729 days ago. His preliminary review was on 5/5/2022. That was 5 months after the Freeman decision. 5 months after the Alan Freeman decision and $50K fine. Remember that decision where his advisor, Don Bray, was directly involved with, called out in the decision the need to take real steps to determine proper amounts and report them. Meaning things like go to the actual vendor. So Emily Cardinal, I'm going to leave Nelson Embry out of this because I believe from his testimony, he was unaware of anything. He never became aware while he was treasurer. But Emily Cardelloni, she works for a firm holding itself out as campaign finance experts, NK Bauer and Associates. It's what they do, campaign finance reporting. Mr. Richter has claimed, I know a lot about campaign finance reporting. I probably do more than most people, but I don't have a firm that does campaign finance reporting. Emily Cardelloni is part of a firm that's what they do, campaign finance reporting. I'd ask you to think about her testimony and how convincing it was of somebody who works for a firm that's supposed to be experts in campaign finance reports. Her efforts were absurd. Never called strategic media placement or Goldstein, never checked the FCC database, never called a radio station. Only basically later we learned that she never was even involved in a conversation with Don Bray. Those conversations were only with Natalie Bauer and Mr. Stewart, and then she was a third person told what was supposedly said about what should be reported or not. And she undeniably had a reason to clean up the reports from April of 2023. When strategic media placement provided the detail. That was 669 days ago. So I'm going to pop back in conclusion here to the evidentiary standard of preponderance of the evidence. Means that the claim must show that their claims are more likely true than not. What were my claims? That the campaign finance report was not complete and accurate. Is it more likely true or false that Brian Stewart's campaign finance reports were not complete and accurate? I think there's no question that that burden has been blown away, that they are not complete and accurate. The people involved with Billingham and, for example, Mr. Goldstein, they still want the money. They're still trying to get the money. So to say that the reports are not complete and accurate would be absurd. I think I've blown that away. I think there's some deliberation needs to happen on the knowingly receiving corporate assistance. But I think the reality of this is the reason why, and I point you to this. Mr. Stewart, both in his testimony and in his immediate original reply, the reason why he's so much, I called so-and-so, 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 I called him again, so-and-so, 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 never did that per Mr. Caraway on any other campaign finance reporting cycle. Did it on that one. Why? Because I believe it's unquestionable that Mr. Stewart knew that there were services that took place that had not been reported anywhere. And what's the absolute evidence of that? He's the one that gave me a copy of his own radio ad that then he acted like here he knew nothing about and never ran. So I'd encourage you to find him. Basically, I don't know what to do with Emily Carloni. If you hold her to the same standard as you would hold me, you know, you can't have firms that hold themselves out as experts at campaign finance, where the treasurer, who's one of the most culpable person for the financial reports, they're the ones that actually file them. You know, where she can't be accountable for that. Okay, as it relates to Mr. Stewart, you know, I don't think there's any question that the reports were not complete and accurate. To the degree that he arrogantly comes in here and doesn't report anything, he's knowingly trying to receive a corporate contribution that's never reported anywhere. Thank you, guys.
Thank you, commissioners, for your time. I know we've been going over this. I looked at the case caption on this case. It was filed in March of 2022, so it's been a long time for you, in addition to a long time for me and the folks who were gracious enough to help me in these various campaigns. I told you my opening what complainant's case would be, and he's basically played it note for note. But before we get to that, you know, Mr. Hicks said, well, if I was in the same situation, here's what I would have done. You don't have to think back very hard to see what he actually did do in almost the exact same situation. Before my case started, he had a case. He had a case where he had not filed a report that he was supposed to file. But his defense was, well, I didn't know the report was due. There was something sent to me, but I didn't receive it. I had no knowledge that this report was owed. And you voted to let him off the hook. You said, well, you didn't know about it, so how can we expect you to file a report and be accurate if you didn't get the notice and understand what was supposed to be in the report? And you let him off the hook. And now here he's been for 3 days straight arguing the exact opposite. He acknowledges that in 2020, when all of his reports were filed, that Friends of Brian Stewart had never been sent an invoice for any unpaid expenses, had never been notified that a radio ad had been run, had never been notified that any debt was owed to anybody. He's acknowledged that. There's no evidence in the record otherwise. At the time these reports were filed, he has shown you nothing to suggest that my campaign committee had any indication that anybody was claiming to be owed unpaid money. And yet, for my committee's standard, it's, well, even though you didn't know, tough. You're on the hook anyway. You need to be psychic in addition to following, you know, a huge voluminous code that has 1,000 potential pitfalls for people who are willing to actually step and put their name on the ballot and try to get engaged in public service. We have to be psychic in addition to following the rules. Has he shown you any evidence, any email, any text message, any documentation whatsoever that in 2020, when these reports were filed, Friends of Brian Stewart had been sent an invoice from Constant Content, JPL, HRCC, or anybody? No, he hasn't shown you that. Did he show you any evidence, text message, email, anything to Friends of Brian Stewart saying, hey, Brian, by the way, that radio ad's running in in Zanesville on the other side of your district, 2 hours away? No. Any evidence that Friends of Brian Stewart said, hey, by the way, we'd like that radio ad to run. We approved you to run the radio ad. Absolutely. Did we record a disclaimer, a one-line disclaimer to have it in the can? Sure. That's not the same as authorizing it to be run. Did he explain to you who authorized the ad buy from Friends of Brian Stewart? No, because nobody did. In fact, we have it in his own exhibits. Who authorized the ad to be run? Strategy Group for Media. Is there any invoice, text message, phone call, any record of any communication between Constant Content, between Strategy Group for Media and Friends of Brian Stewart at any point? No, it's not there. Who authorized the radio ad to be run? We know that. A. Brant Fink. He works for a company that's not Friends of Brian Stewart. Any communication, text messages, phone calls, emails, anything between Mr. Fink and any member of Friends of Brian Stewart? No. Did he show you any evidence that Friends of Brian Stewart was given notice that an in-kind expenditure had been made by anybody? We know how to report in-kind expenditures, folks. You can look through the reports. We do it all the time. The way you do it is somebody says, I made an in-kind contribution to your campaign. Here's the amount. I'm the person that did it. Here's how you can report it. Any evidence from him that Friends of Brian Stewart had received any such communication at any point before the campaign finance reports were due? No. No, that's his burden to bring that in. He didn't do it. Talk about that demand from Constant Content for $13,000 that Mr. Hicks thinks we should have just rolled over and paid from an individual who was under federal indictment, had turned over this case to a collections firm. We should have just rolled over and paid it to the indicted owner of the firm. Did he show you any contract between Friends of Brian Stewart and Constant Content? No. Any contract between Friends of Brian Stewart and JPL, HRCC, anybody relating to radio? No. Didn't show you a thing. Did he show you any evidence that there was actually a mailer that was printed and mailed, but not paid for and reported? No. The only reason you have any pieces of mail draft in front of you is because we gave it to him. He doesn't have a single piece of mail in evidence to show what was actually sent. As far as this commission is concerned, there is no evidence in the record after 4 days of what any mailer looked like that was actually sent. He doesn't have one. Those mailers have addresses on them. They have mail stamps. Does he have any of those for you? No. 4 days of testimony, he hasn't done basic homework to go find an actual piece of mail that he claims we didn't pay for. Not there. All you got from him was the same old hits. Freeman Schmidt, Freeman Schmidt, Freeman Schmidt. Alan Freeman and Gene Schmidt were not endorsed by the Ohio Republican Party. That is a huge distinction. All of their campaign activity went through their own campaigns. My campaign was endorsed by the Ohio Republican Party, and so all of our campaign activity was done by somebody else. It was done by the ORP. Every single piece of mail that was produced by the state party. They sent the mail. They reported to us that it had been sent, and we properly reported it on our campaign finance report. On the other hand, what evidence did you get from the respondents? You heard Emily Cardelloni explain how these issues were debated, researched, vetted with legal counsel, and then an attorney and compliance professionals, 80+ years of experience, concluded that Friends of Brian Stewart's 2020 campaign finance reports were completed properly. Folks, the standard is failure to file a report. As in, at the time you filed the report, was it true and accurate? Was it true and accurate to the extent that you could be aware? Not that we're going to have a continuing standard for 10 years that if you pull something in 2020, was the report timely and accurate? If you file your tax returns and you tell the IRS and you say, I have 3 children, and then the next year, someone comes and says, surprise, actually you have 4 children, okay, long lost child here. That doesn't make you guilty of tax fraud for filing a report that was true and accurate to the best of your knowledge at the time you filed it. And our campaign finance laws, if that is the way they're going to be interpreted, good luck finding people to keep running. You heard Stephen Caraway explain how Friends of Brian Stewart, after the 2020 primary, reached out proactively to explicitly ask multiple people, do we owe anything? Is there anything else that needs to be paid? We want to pay it. We have $70,000. We would like to pay any bills that we owe. What were we told? No, 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 no. Time and time again. It is unbelievable to hear Mr. Hicks now fault the committee, fault Friends of Brian Stewart for being proactive in asking those questions. We're damned if we do, we're damned if we don't. If we do ask, under Mr. Hicks' construction, if we ask whether we owe anything, that's indication that we're guilty, that we think we might have owed something. That's absurd, folks. It's absurd. The standard that he's talking about from your Freeman decision, did we take efforts to find and report the truth? Absolutely. Absolutely. We asked all the people who would know whether we should have owed anything, do we owe anything? And all the people that were in a position to know the answer told us no. He says we're not supposed to take no for an answer. We're supposed to just keep asking. You heard me explain under oath the plain fact that I never authorized a radio ad to actually be run. I'm sorry if Mr. Hicks doesn't understand how campaigns work, but sometimes you put together materials to be prepared that may not ultimately be used. That's what happened in the case of this radio ad. Has he shown you any evidence that I was aware that a radio ad was running in Zanesville, 2 hours from my house? No, of course he didn't. You saw the letter from Friends of Brian Stewart in September 2021 disputing that any amounts were owed to Constant Content for anything. We asked, again, report and find the truth. Constant Content, can you please produce a contract that shows that we owe this? Can you please explain what you've done? Can you please show us that this is not a duplicative bill that you're trying to gouge us for 18 months after the fact, now that you're under indictment, Mr. Longstreth? Can you please just prove to us that this is a legit expense that we need to pay? Did he show you any response from Mr. Goldstein? No. Mr. Goldstein did nothing. No response. No proving that this was a valid debt. But apparently, we're supposed to assume it's valid even though nobody proves the case. Heard a lot of discussion about, well, if Brian Stewart had just come in and said that I was right about everything, this would have all been over. Well, yes, that's how courts work. Yeah, well, all cases would go quicker if the defendant just rolled over and agreed that the plaintiff is right. That's not how due process works. Let's be real. There is no, as we talked about before, what amendment would be filed to say that who made the in-kind contribution? Was it HRCC? Was it JPL? Was it Constant Content? Was it Strategy Group for Media? Any report, any update that Friends of Brian Stewart would attempt to file today would itself be a guess. It could be just as inaccurate as what he claims the current reports are. And let's not be Pollyanna about this. He wants us to file an amendment so that he can file another complaint saying that we amended it the wrong way. That's what's happening here. He's telegraphed it to you. He is dying to have an opportunity to come in and say, well, you filed an update that said you got an in-kind contribution from Constant Content. Wrong, false report. You actually got an in-kind contribution from Strategy Group for Media, and that's a corporate contribution, and now you're guilty of a felony. That's what he wants you to do. It's all a big game of gotcha. we're gonna talk in a minute about the hopeful outcome of this case. But I would just say, if you were to actually hold to what Mr. Hicks is arguing, that Emily Cardellone, who was not the treasurer in 2020, who did not file any campaign finance reports, and who became Friends of Brian Stewart's treasurer 18 months plus after those reports were filed, that she is somehow liable for a prior reports that she did not file. I'm going to go back to my law practice and advise everybody I know to never, ever agree to be a campaign treasurer for anybody ever again. That would be insane. Emily Cardellone has nothing to do with this case. She is my current treasurer. She was not the treasurer involved in any of these reports. So if the commission is inclined to, want to follow this rabbit hole and find liability for Friends of Brian Stewart, I would certainly ask that you leave it there and not with a treasurer who was not even the treasurer when the reports at issue were filed. Commissioners, we have gotten deep into the weeds. A whole lot of statutes, a whole lot of back and forth. I would ask you to just put that aside for a minute and put yourself in my shoes and say, what the heck would you do different? You filed reports in 2020 based on all the information you had at the time. There's no indication that we filed anything incorrect in those 2020 reports, other than the fact that Mr. Hicks thinks that 18 months later, we should have updated them. You get a demand for payment from somebody who's been indicted for fraud, demanding additional money after they told you 18 months prior that you didn't owe them a dime. Mr. Hicks would say, you're supposed to just take their word for it. Pay no attention to those indictments. Pay no attention to the fact that they already told you you owed zero. Pay it and move on. You have a great big mess, admittedly. It's a great big mess. Not trying to pass any bucks, but Friends of Brian Stewart didn't create the mess of Larry Householder and JPL and Associates and all these folks who are now indicted. We didn't make the mess. We're the victim of the mess. Ask yourself what you do in that situation. What's the out? Do you guess again? Well, I guess I could file an update and guess at the amount and guess who paid it and guess which organization it is, knowing full well you're just going to get sued again for the exact same amendment. That's why we don't amend. We want to wrap up this case. In 2020, did we fail to file an accurate report in 2020? No. We did everything we could with the information that we had. The Ohio Revised Code says that the rules of civil procedure apply in these hearings. The rules of evidence are supposed to apply in these hearings. He has not shown you evidence. He has the burden to prove his case. We don't have the burden to prove we're innocent. We've done it anyway, but but we don't have the burden. We would respectfully request that you find no violations and dismiss these complaints and put this matter to bed after 3 years. However, in the alternative, the Administrative Code 3517-1-14C authorizes you to find a technical violation but impose no fine, which we would request in the event that you are determined to find a technical violation. But commissioners, I'll tell you, you've heard in detail for 3 years how we worked and worked and worked, bent over backwards, called, verified, talked to attorneys, talked to treasurers, did everything we could to do things the right way. And if you still find that that's not enough, folks, there's gonna be an awful lot of discouraged candidates and office holders in Ohio, because I'm not gonna have an answer for them of how you run a campaign, do everything you can the right way, be transparent, and still get hammered by the commission. That's a problem. And I hope you don't compound it by following Mr. Hicks' lead today. Thank you.
Are there any comments, any dialogue, questions of the commission members?
Just, Madam Chair, I have,
Yes.
thank you. So this is really for Mr. Richter, and it's along the same lines of the question that I asked Representative Stewart. And let me preface it by saying, I think two things can be true at the same time. I think that I can find that Representative Stewart is credible, that he did his due diligence, that he was in a tough situation, as he just said. But on the other hand, I also know, sitting here, that there has been testimony through particularly Mr. Schweitzer, okay, that there was a radio ad that was produced and ran. We all know that, we all heard it, and that's not refutable. Nobody refuted that. So my question to you is, in a situation like this, where a person has done, let's just say, their due diligence, but during the course of a hearing finds out that there was, I guess you could say, that something was produced, which it was. What is the responsibility of the candidate in this case? What do you see the responsibility of Mr. Stewart being?
Difficult question. I guess you could, I mean, as he kind of even argued, you could file some sort of an update. But, at the time when all of this was occurring, there was no information given to him at the time that any of that had been done, and he was told that there was nothing out there. And certainly from generally speaking, how addendums to campaign finance reports work, you have 21 days from the time when you are apprised of a situation to file an update or an addendum to your campaign finance report.
So let me interject. So,
Well, I was just gonna say, you could kind of assert that, okay, he was apprised here of that situation as a part of the evidentiary testimony. But I will give him the credit of being, he has disputed that he ever was really received notice, based on his challenge to Mr. Goldstein's the letter. So it is a challenging situation. And I'm not sure exactly how to answer that question. Or that I've got a good answer to it, at least.
so if he was to amend a report, what would it look like? Because he says, and I don't disagree with him, he says he's damned if he does, damned if he doesn't.
Right.
So what would that actually look like if he had to do that?
Again, I'm not certain, because who is it that, you got the billing, as it were, from Constant Content, but who was it that actually paid for the the production and the running of the media? Was it Strategic Media, and that's who you would identify as the organization that gave the in-kind contribution? That's,
Well, yeah.
I don't know. That's the challenging situation that we are currently faced with here, as you kind of assess all of what's going on under this set of circumstances. I wish I had a better answer for you, but I don't know that there's real clarity as it relates to the circumstances here, as it relates to who would be identified as the responsible party.
Make a recommendation. In the event that all was done in good faith effort at the point of it being due, which as a candidate, you can't know what you don't know until you know. And the evolution of this case and these hearings has presented information that might cause you to want to go out and seek clarity. I can't imagine that going directly to the vendors that provided the output, they wouldn't be able to tell you who contracted them. So there, where there's a will, there's a way. I think that this can be resolved and put to bed. And I might ask, would it be appropriate to seek those invoices through those avenues at this point in time, now knowing what we know, and just make a good faith effort with current and modern invoices that are being invoiced in live time and amending the campaign finance report in live time, not necessarily an amendment of what you didn't know when you didn't know it, but giving an opportunity for compliance in the window that you've been made aware. Because I agree. I think any candidate would be hard pressed to participate in a system where they have no way of knowing how to be in compliance when they don't know what they don't know. And I think our goal is compliance. And I think this case was pending based off of an incomplete filing. But at the time of the filing, it was complete based on the knowledge at hand. So I think all of us want them to have the opportunity to complete the filing now that they know what's been presented in this room.
But I'm still confused, and I'm sure the respondent would be too, is how would he file that? That was my question to Phil.
Would it not, I mean, would you not talk to Schweitzer and see who contracted him?
Paid for that.
Well, we know who contracted him.
We don't know who paid.
Megan Fitzmartin instructed him, right? And then Constant Content was the one that paid for the ad, did they not?
It would, best answer I have there is it would appear, yeah.
Yeah.
But could you get concrete evidence of such? That's essentially when you're saying, I don't know what this bill is for. I need a breakdown of the invoice, a breakdown of the bill. You're essentially doing that in good faith effort in live time that you've learned more information, giving yourself an opportunity to get it right. So, I mean, I think that you could accomplish it, I would imagine.
Madam Chair, if I could, and to direct to Executive Director Richter, I think that the respondent has had an opportunity to evaluate its own position, his own position, and has determined the manner in which he'd like to proceed. Not our position to provide legal advice to them. I think that the issue on the table here at the conclusion of the case, which has been concluded, the request from the complainant is to find violations. The request from the respondent is to either find no violation or to find a violation and issue no fines. If the respondent, for example, would have wanted to amend, he would have done so, but he spent a good deal of time explaining why he doesn't want to do so. Seems to me, and I'm ready to proceed to the vote, but I certainly would want everybody to have a chance to air their comments and concerns. We have to make a decision as opposed to providing advice to the parties.
I guess, Madam Chair, if I may, I guess, Mr. Kirschner, I disagree from the standpoint that there would necessarily have to be a violation. I think a report could be corrected without an actual violation. Am I wrong there, Mr. Richter?
No, I don't believe you're wrong as it relates
I
to.
mean, if we find that Mr. Stewart did his due diligence and everything else, and he does make the case, which he reminded us of the case that, and I think I'm the one that led it for Mr. Hicks. I think I made that motion. So I'm just saying, I'm with you halfway, but I don't know necessarily there's a violation. Particularly once we find something out in a hearing that he didn't know, obviously. But there's evidence that Mr. Schweitzer provided that it ran. That's why my question was again to Mr. Richter about how would, and I'm sure Mr. Stewart would have that question. How do I book that? Do I just say there's a debt from who, if he's disputing, constant contact, which is what he's doing. But
Yeah.
we know there was obviously an ad run.
Right.
Am I being clear here?
Yeah, I think so, but it's just, first off, it's not a situation that we have had
Right.
presented to us previously. And, as I think about all the various things that we've decided over the years, there hasn't been anything like this. And I think, there's been a lot of references to Freeman and Schmidt, but particularly as it relates to Freeman, there was much more direct knowledge of what had occurred in that case. You guys weren't around for that one, but there was a lot of direct knowledge that Mr. Freeman had of media being run and so forth, that Mr. Stewart has indicated, he was never apprised of that. And so I think to me, at least, there's a great difference between the determination in that case and what the commission found as it related to Mr. Freeman, as it relates to the circumstances here. Mr. Freeman participated in the production of, and it was television media as well, participated in the production, discussed it with Fitzmartin and other staff, and all that came out in the hearing. And here, what you're hearing from Mr. Stewart is there was nothing, at the time when the reports were to be filed, there was nothing that ever came to him as it related to that. I mean, and like I said, this is an incredibly novel situation. I mean, could a campaign finance report could an addendum be filed? While it's simple to say yes, I'm sympathetic to Mr. Stewart's assertion that, how would it be listed? And having not had anything like that previously presented to us, I'm not exactly certain. Because you don't have a situation where, an addendum request was received that identifies the start date from when you have an obligation to file that addendum. Mr. Hicks would have us say that, well, once he got that demand notice from Mr. Goldstein, that essentially started it. But he has asserted that he's asked for more information to confirm that that's the case and never gotten it.
And yet we're stuck with a decision.
Yes, we are.
Okay.
Mr. Benjamin, Mr. Ritter. So I'm not saying I'm there or not there, but let's say that the commission's view was that the radio ad was an in-kind to the Stewart campaign. Okay, let's hypothetically say that. And let's say that that in the view of the commission as of today, and started a 21-day clock or whatever it is, right? So two questions. One, would you, in your opinion, would the reporting that's in question be in compliance with the law or not? If what this commission view is that the radio ad was an in-kind, would it take that out of compliance as of today?
If it was to constant content, the answer would have to be yes, because
It could be anybody who overpaid for it, right?
right.
Okay. So, so that's question one. Question two. I mean, if it's constant content, it's easy, but you call them up and they tell you who paid for it, right? Whatever. Let's say it is a unknown contributor. Is there something in Ohio election law that would allow a report to say a in-kind contribution from an unknown source, but with X amount of diligence done to make it in compliance?
There are opportunities for, if there is an element of a campaign finance report that cannot be specifically identified, if you use your due diligence in trying to get information as to where either the contribution or the expenditure came from. You can express that, and I know, and not necessarily in a context like this, but in having conversations with either a board of elections primarily, or a candidated issue. I've encouraged persons to, when they file a campaign finance report, to identify, when they have been in that kind of a situation where there's something that occurred, either again, a contribution or expenditure, and they've used due diligence to try and identify that and have not been able to include that in a campaign finance report, and include that with an explanation of the circumstances and the facts, as an effort to try to come into compliance under that set of circumstances. Yes.
Thank you.
So Phil, what would the verbiage look like?
Something akin to, I've been apprised that this, again, contribution or expenditure was made on behalf of or to the commission or to the committee, and looking at it as, let's say, in terms of somebody gave $100. I mean, you've probably been to those kind of things before, where there may be a pot of money out there. I'm not saying that I encourage that kind of circumstance, but the only thing put in there is $100 bill, which, would be within the allowance for a cash contribution. And, you go around to all the people at the event and try and say, did you do this? Do you do this? Do this? And you still take the $100. I mean, that's a really bad example, but, in a situation like that, explain what it is that you did to try and make sure you use your best efforts to identify where that came from. Or, you become aware that, maybe there was a radio ad run by somebody out there that should have been an in-kind contribution to your campaign committee. But you don't know who it was from. You just hear it out there some randomly. This is, again, a bad example, but under the circumstances, or you see a piece of literature that somebody ran that said, vote for Brian Stewart. And you reach out and you try and, you talk to the Postal Service about where the stamping came from. You do whatever it is that you find necessary to try and identify a responsible person for that. And then you lay that kind of a statement out in your campaign finance report that indicates what it is that you've done to try and identify either the contributor or the person that made the expenditure on your behalf, and put that in a campaign finance report to identify that you've used due diligence to try and identify whatever it may be.
You're also referring to this in the same time frame and context in which that action transpired. So this would be a unique amendment of sorts if it's not directly reconciling with lifetime actions. Is that correct?
I'm sorry, say that again.
Would this be unique in that you're amending something not in the same cycle in which the expenditure is actually transpiring?
Concerning this passage of time, I'd say yes, but other questions that I've had posed to me, maybe outside of the immediate time frame of when a report was going to be filed, but not this length of time. Yes.
Madam Chair, I guess I'd like to sort of summarize my thoughts on the matter, that this is kind of collateral damage, carnage, an unfortunate part in our history, electoral or otherwise. I think we look at the fact that it was brought up, at the time, were these truthful and accurate, and to the best of their knowledge, absolutely. And then what, year and a half later, they get the letter from Mr. Goldstein, and they did inquire. First of all, he wanted to clean up things back in the spring of 2020, I guess, whenever that was. And then he did inquire when he got the letter from Mr. Goldstein. And above and beyond that, we've got a lot of exhibits flying around, a lot of things that I'm not really sure. I mean, if you're really a court of law, and I think we're supposed to abide by the rules of evidence, they didn't really been authenticated. I mean, Mr. Goldstein was here and talked about his letter, but we have this constant content thing that, yeah, well, that kind of looks like a constant content. So there's a lot of inferences woven throughout this, and with a little bit of Freeman and Schmidt thrown in. But if you separate out and have this as a standalone case and look at it individually, I just don't see it. I mean, at the time, there was nothing to say that they knew this was there when the pre or post primary had to be filed. From then on, he got the letter from Goldstein. He did inquire and didn't hear anything else. And from then on, you're in a game of gotcha, which I think we're on a very slippery slope. And our prior hearing and decision was a bit of gotcha, where there was an amendment filed in the course of the hearing. And it was, see, I told you. And I think that's an incredibly slippery slope to go, notwithstanding the fact that, again, what do you do? Is it in kind? Is it a debt owed? To whom? Was the radio station ever paid? The letter from Mr. Goldstein say pay Mr. Goldstein. Is he owed the money? And we don't know. And I think it would be dangerous to impose a burden of absolutivity this far after the fact, that you've got to, prove beyond a reasonable doubt, whether or not, any money is owed. So.
I mean, Madam Chair, if I could, agree wholeheartedly with Mr. Stoutberg. I guess I'm guilty of jumping to the end conclusion because it appeared to be obvious. But I voted for directed verdict, so I think we know where I stand. I agreed with the comments made by Mr. Stewart in his closing, which echo what Mr. Stoutberg said in his summary. There have to be basic evidentiary standards to prove the case up. I don't think that the evidentiary standard was met. I sit in the same position as I did on the directed verdict motion, but it seems relatively obvious from my perspective, and I do agree with my fellow commission member.
I agree with everything except, my only question is, I lean to the radio ad being an in-kind, and whether or not we should find no violation, but ask for a period to have that be in compliance in some way, shape, or form.
Very good. Well, I appreciate all of the perspectives, the dialogue. I think that this has been very thoughtful and well deliberated case. There's nobody that could deny that it's been provided ample hearing time. If they're based off of your assessments, your conclusions, your conversations and input, is there a motion to move the commission forward on this matter?
I move that we find no violation.
I second that.
I see we have a motion and a second. All in favor signify by
I think we should do a roll call. Would be my
okay.
belief, at least. Let's put it that way.
Proceed.
Okay. Mr. Lyle,
Why don't you come back to me? I'm still thinking.
Mr. Knight,
Oh, man.
Got to be quicker to the trigger if you don't like the motion.
Aye.
Ms. Davis,
Yes.
Mr. Kirschner,
Yes.
Mr. Stoutberg.
Yes.
Now I'm coming back to you. Mr. Lyle,
Yes.
Chair Hagan,
Aye.
that motion passes unanimously.
Moving on. Does anybody need a 5-minute recess before we?
I move on to an motion to adjourn.
Okay. All right, very good. Thank you all for your time and attention. We recognize that. Long case. Okay,
So Mr. Knight, you move to adjourn?
I'll second.
Mr. Kirschner seconded.
all in favor, signify by saying aye.
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 Unanimously along.
Place, that was my, it's really pretty good. Process at the end.
I know, I heard you thinking.
Thank you.
Walking away with it.
That's very pretty.